In this week, we'll continue to look at criminal procedure and we'll focus on one of the most important stages in the criminal process, arrest and bail. Bail is conditional liberty that's granted to an accused person pending the determination of their criminal charges. A grant of bail is about balancing the rights of an accused person and the protection of the presumption of innocence with protecting the community from criminal offending. Bail is regulated by the Bail Act 1978. Bail can be granted at every stage of the criminal process. It can be granted by police, by bail justices, or by the courts. The tests which apply to an application for bail depend on the nature of the charges and on the accused person's circumstances. In all applications for bail, the court's inquiry centres on the risk factors for a grant of bail. If the accused person is at risk of reoffending, not attending court, endangering the community, or interfering with witnesses, then the accused will be deemed to be an unacceptable risk and bail will be refused. The highest threshold for a grant of bail is the exceptional circumstances test. People are placed in this category due to the nature of the charges they face. Accused people who are charged with murder, terrorism, or trafficking in a large commercial quantity of drugs must demonstrate that there are exceptional circumstances to justify the granting of bail. Even if this high threshold is met by the accused, the court must also consider whether or not there is an unacceptable risk in granting bail. A person who is charged with murder can only be granted bail by the magistrate who commits that person for trial or by a judge of the Supreme Court. People who are alleged to have offended while subject to a grant of bail must show cause as to why they should be granted bail. This category also applies to accuseds who commit aggravated burglary, certain family violence offences, or offences whilst being armed with a weapon. The threshold for showing cause is lower than that of exceptional circumstances, but the court will consider similar factors. Matters such as the strength of the prosecution case, the delay in the matter coming to trial, and matters personal to the accused will be considered by the court in making an assessment about whether the accused has demonstrated cause. Accused people who do not fit into the category of exceptional circumstances or show cause are deemed to have a prima facie entitlement to bail. Therefore, as long as they're not considered to be an unacceptable risk, the court should consider releasing them on bail. This class concludes the procedural aspect of this course. Next week, we start having a look at substantive offences.